Hi, my name's Katie and I'm one of the attorneys at the Liker Law Firm. Today I'm going to talk about a few options that you have in dealing with property when you're filing for bankruptcy. I'm going to focus on three: redemption, reaffirmation, and surrender. Redemption is one of your options. It generally applies to cases where the property is now worth less than the actual loan value. So for example, if you have a car that's worth $10,000 and the loan value is $15,000, that creditor is now undersecured by $5,000 because the collateral is only worth the $10,000. So in a redemption proceeding, what you would do is give the creditor $10,000. So you are paying off the secured portion of what the loan is. Then through filing for bankruptcy, we wipe out the remaining $5,000 that's now unsecured debt. At the end of the proceeding, you then own the collateral, in this example the car, free and clear of any encumbrances. But this option does require that you have a lump sum payment of whatever the secured portion of the loan is. Your second option is a reaffirmation agreement, and this differs from redemption in a few different ways. Basically, what a reaffirmation agreement does is it's stating that you'll continue the loan in accordance with the original terms. So you don't have to have any amount to pay up front. You just keep making your monthly payment or whatever you had originally agreed to. In this case, you don't necessarily own it free and clear after the bankruptcy. It would depend on how much you owe and how many more payments you have. With this, you might be subject to foreclosure or repossession if you're later unable to make payments in accordance with the terms of the loan. However, this would allow you to keep your property, assuming that you can afford it. The final option is a surrender. In a bankruptcy proceeding, you can indicate that you're no longer interested in the property. You walk away from it owing nothing. You can surrender property completely irrespective of what the property's worth or how much you still owe on the property. When you do this, you turn over the property, usually at an arranged time, and your lawyer can certainly give you more advice about that. And you walk away. You don't owe anything else. You have no further financial obligation to pay, but you also do lose possession of the property. So those are your three main options: redemption, reaffirmation, or surrender. And if you still have more questions, give us a call and we'd love to make you an appointment.